Lawyers of Reddit, what was the best gotcha moment you ever experienced? I was defending a guy accused of third-degree assault on his girlfriend in a misdemeanor trial. She had a bruise on her neck and told the police that it was from my client strangling her. Somehow, it got around the public defender's office that someone overheard the victim admit to her mother that it was a hickey. Remember that movie where Tom Cruise was standing there, struggling whether he should accuse Jack Nicholson of ordering the code red? It was like that. She was on the stand, and she was terrified. I was battering her with answers, not open-ended questions, as it should be. It also helped that I had a projector slide up on a screen in the courtroom of a massive butcher knife stuck in the wall. Yes, she threw it at him. I had her admit that, but that wasn't the clincher. It was the moment when I decided while standing in the middle of the courtroom whether or not to assert that the bruise on her neck was actually a hickey. I didn't even know if it truly was at all. I mean, it was hearsay within hearsay with a double smattering of more hearsay, but I wasn't going to assert it as if it was overheard. I was going to assert it as a fact. The trouble I had with this decision was that what if I asserted it was a hickey and she said no? I would look like a massive idiot, and it only bolsters the DA's case. Anyway, I said screw it, and I asked her, "Isn't it true that the bruise on your neck is a hickey?" She breathed out, slumped in her chair, and said, "Yeah." We won. I knew the cops beat up my client and framed him. They described a knife in his possession that caused them to fear for their safety. Oddly, they never seized it. We won the criminal case and filed a civil rights case. While deposing one of the cops, he described the knife in detail. No more than 3 minutes later, he slipped up and claimed his partner told him my guy had a knife, but he never saw it himself. I told him, "That's not what you just said," and saw him panic. His lawyer panicked too and asked to see me outside. When we got in the hallway, I withdrew my settlement demand, and the case settled for a substantially larger amount within 45 minutes. It was day 2 of a child custody modification trial. The opposition and her attorney were batshit crazy. Their allegations were so weak that I told my client, "Screw it, let's go for custody ourselves." I'm cross-examining the mom about her proposed custody plan in some detail, and I ask her, "Would you accept this for yourself?" She snaps back, "Absolutely not." I ask, "Why not?" "Because I'm a mother." My guy kept a straight face the entire trial and never once got pissy. Her petition was denied outright. Ours was accepted by the court. If the mom or her lawyer hadn't been such a pain to deal with, my guy probably would have agreed to some small reductions in his custody just to keep the peace. Instead, the judge gave us nearly everything we asked for. I had a case of accused grape. During the process of speaking with the victim, she stated that the suspect had held her down with both hands to pin her hands above her head while he sat on her hips. She then explained that he took one of his hands and took off her pants. Prior to this point, nothing made a lot of sense. She was married, had a secret boyfriend, and this guy, the accused, was another boyfriend. Her first boyfriend found out about this second tryst and lost his mind. Come to find, he coaxed her into claiming grape because he said it was impossible that she would be sleeping with anyone else. All of this came from her best friend, who I had interviewed without her knowledge. The victim explicitly told her friend to go along with the story she and boyfriend number 1 had created. Back to the victim interview, she detailed to me the event and what came after. I had her go back over to the beginning and asked her again with as much detail to recount the events. She got to the point where the pants came off. I said, "And how did he take off his pants?" She stopped speaking and froze. Her lawyer literally exhaled and fell into his chair. She said she didn't know. I said, "I need you to explain this as it is part of your official statement." She said he just took them off. I said, "I understand, but how? You said his hands were pinning you down and he was sitting on your hips." She looked at me wide-eyed and gasped, "Oh God, f***." I questioned a key witness in a civil suit while I was still in my training days. The witness had a speech impairment and explained that he had a stroke. I asked if and how it affected his memory, as the matter we discussed happened a long time ago, and he seemed to remember it in perfect detail, which was odd in itself. He said he had trouble with anything from the past and couldn't even remember his wedding day. He cried a little saying that. I asked how it was possible that he could remember events if he couldn't remember his wedding day. In complete naivety, he then told the court that the plaintiff had told him that's how it went down back then. I asked when they had been in contact with each other. The witness went on to say that he, of course, had no memory of events, but the plaintiff had visited him daily up to the day before the hearing, reassuring him that these were the facts, and that was what he should tell the court. You could hear the plaintiff cringe. If you enjoy this video, please give it a thumbs up and subscribe to my channel. Thank you. My former law partner was in court representing a client. I think it's a hearing for a restraining order against her soon-to-be ex-husband. Our client was telling the judge that when they met to exchange the children for visitation, the ex had kicked her. He immediately angrily shouted, "She can't prove it! I didn't leave a mark!" It was my third month of practice. I was in family law at the time. I represented a mother in a petition for a restraining order against her ex-boyfriend. At issue in the broader case was child visitation, custody, support, etc. But today's hearing was just on the restraining order. We had pretty good facts, but it was mostly based on testimony of the parties. My client was way more reputable as a witness, so I was feeling confident. 10 minutes before the hearing, my client shows up. I give her a last-minute prep on what to expect, and then she says, "I'm glad I'm going through with this. I can't deal with it anymore, and he's just getting worse." To top it off, he left me a drunken, ranting voicemail on Saturday. I asked her, "Do you have your phone with you?" She said yes. We play the voicemail, and it's a full 2 minutes of ex-boyfriend screaming stuff like, "I should have killed you when we were together. You were always such a bitch. I hope you burned to death in a fire." I didn't have time to ask her why she hadn't said anything to me about the voicemail before the bailiff called our case. We sit, the judge asks if either side has additional evidence, and I ask for permission to play the voicemail. The ex-boyfriend, who didn't have an attorney, didn't object, so I played the whole nasty 2-minute rant in open court. The boyfriend knew he was screwed. We settled the whole case then and there. My client got her wish list in terms of custody, supervised visitation, child support, plus the restraining order. I was defending my client in a felony family violence assault case. My client and his girlfriend had been in the car together, and she claimed that he beat her while he was driving them around, speeding and drunk. She had even called her mother during the drive and made an outcry to her on the phone that he was punching and hurting her. She said he caused 2 wrecks, and he broke her nose and busted her head open. My client denied it all and was promptly arrested by the police. She told a great story at trial, which was well received by the jury. That was until I played the cell phone video my client had taken during the drive, which showed that she was the one driving, that she was intoxicated, that she caused the first wreck, then drove off without stopping, and that she blew through a red light and caused the second wreck. It also showed that while she was calling her mother and screaming about him abusing her, he was calmly sitting in the passenger seat, not moving and begging her to stop the car and let him out. The judge stopped the trial, thanked and excused the jury, and directed a not guilty verdict for my client. He then had the girlfriend stand up and he Mirandized her, telling her to find a lawyer to defend herself, as he would be recommending perjury charges against her to the district attorney. My guy had been charged with assaulting the same woman 3 months before, and then charged in another county with violating a protective order she had out against him. So we used her perjury at our trial to get the other charges thrown out. And yes, my client was a moron who continued to date this woman. My grandfather was a small-town Georgia lawyer, and he told of a time he was representing an insurance company in a civil suit after a car accident. The plaintiff claimed to have received whoop neck from the accident, supposedly caused by my grandfather's client. Pop asked him what exactly he meant by whoop neck, and the plaintiff, wearing a neck brace, proceeded to answer, "It's when you can't move your head like this." And then he shook his head back and forth. The judge promptly dismissed the case. Custody case. We all knew the mom had drug issues, but I was actually asking about another subject at the time, and I brought out a letter she had at some point written to the judge across town, begging for her license back, claiming she had gotten sober and cleaned up her life now. This letter was in the public record from the other case. As a complete surprise to me, she freaks out, asking me where I got this letter. She claims someone must have broken into her house and stolen her diary. Then she says, "You can't hold that against me. I was high when I wrote that." So yes, if that wasn't clear, while she's currently on the stand, swearing to one judge that she's clean and sober, She admits that she lied to another judge about being clean and sober in an official court document. She was so high, she doesn't even remember submitting the letter to the court and accuses me of stealing it from her diary. Not a lawyer, but a detective. I was at a trial of a guy accused of stabbing his wife. She lived. His defense was that she was trying to stab him, and her injury was accidental as he was trying to wrestle the knife out of her hands. He had cuts up his arms, but we got a medical expert to look at them and she had testified that they were self-inflicted, so our case was that he had done it to himself after stabbing her to set up his defense early. The defendant took the stand, and after about 20 minutes of cross-examination from the prosecutor, he was asked, "Why would she be trying to stab you?" To which he answered, "Well, I just stabbed her." Took the jury about 20 minutes to find him guilty. I watched my lawyer have her gotcha moment last time we were in court. My ex abused my kids, so I withheld visitation and hired a lawyer. I offered supervised visitation with a plan to integrate regular visitation once he completed anger management and parenting classes, as well as being 6 months clean of all substances. When he was on the stand, he mentioned that he had been taking prescription meds for 10 years, to illustrate that he's been on meds for a decade and never had a problem being a good dad. My lawyer asked what meds, and he listed off a bunch. Meds like methadone, Klonopin, Vicodin, OxyContin, etc. She asked why he began taking those particular medications. He replied, "Well, I messed up my back last year riding my quad." She asked him to repeat himself, and so he did. The look on her face was amazing. She said, "So you've been taking large amounts of meds for 10 years?" He said yes. 10 years of major medications due to an injury that happened 2 years ago? The judge agreed with my request for supervised visits pending his completion of all the necessary steps. My ex never completed any steps, and my kid hasn't had to see him in 4 years. The complaining witness accused my client of harassment and stalking. She said that she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, and wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. The girl had dozens of photos of the guy, who was clearly her boyfriend. I showed her one such picture. "This is Mr. So-and-so, right?" "Yes." "In this photo, is he on a bed?" "Yes." "And the bed is yours?" Yes." "Did you take this?" "Yes." "And in this photo, is he wearing your lingerie?" "Yes." "No further questions, Your Honor." I had a plaintiff who argued that during his bladder augmentation surgery, the surgeon, my client, was wearing a necklace that fell into his bladder. He claimed that 1.5 years after the surgery, he started getting UTIs and bladder infections very frequently, and upon exploratory surgery, a chain-link necklace was found. Obviously, my client did not wear a necklace into the OR and the story didn't add up. In the plaintiff's deposition, his wife admitted that since his recent accident that had left him a paraplegic, they had found that the only way to assist him in becoming aroused was to thread things into his urethra. Yep. His very own wife led us to discover that this dumbass had threaded the necklace in himself and got it stuck. He panicked and didn't tell anyone or seek medical attention for months. When he started getting infection after infection and the surgery found the necklace, he blamed the surgeon who did the bladder augmentation instead of telling the truth. People are weird. I'm not a lawyer, but I was a defendant. I was a concierge and named in a lawsuit against the building by an unlicensed realtor who was barred from entry after headbutting me while he was wearing a bike helmet. He was representing himself in court. He cross-examines me over how I had barred him from entry and had some preamble about the vendetta I had against him. Then he asked me to repeat what I said when I asked him to leave the building. I responded, "Was that before or after you hit me?" He immediately answered, "After I hit you." It took him a minute, but his face fell pretty far after he caught on to what he just admitted. Case dismissed. One time this lady was trying to defend herself in court about a DUI she received, saying she wasn't drunk when she crashed and damaged property, and that she was just avoiding a deer. They showed photos of the scene and she screamed, There it is! There's the deer I almost hit! She was pointing to a lifelike deer statue on someone's lawn triumphantly like she had just won her case. The lawyer asked, "Wait, this deer? You said it was in the middle of the road. This is on someone's lawn." She said, "This is the one I almost hit." "But it's on someone's lawn. You said the deer was in the middle of the road and that's why you swerved and crashed to avoid it." "It was in the middle of the road! It ran right out in front of me!" "This concrete deer ran out into the road in front of you?" "Yes." She did not win her case. I'm a paralegal, but we had a beauty one time. It was a defamation case where the defendants were accused of posting hundreds of false claims on various websites against the plaintiff, who is a doctor. Things like him graping patients or being drunk during surgeries. During discovery, they turned over hundreds of pages of emails, usually in threads. Around 300 pages in, I found a single email reply about 10 deep in an email chain, where they discussed the doctor, ex-husband of one of the defendants, that said, "Just keep posting. We'll get him where it hurts. Right in the pocketbook." The case settled quickly after that. I was prosecuting a convenience store owner for luring a young girl back to a part of the store to fondle and kiss her. It was the only section of the store without surveillance camera coverage. They were in the back room for about 2 minutes and 17 seconds, per the timestamp on the videos. Of the many arguments the defense put on, one was there was no way there was enough time for anything to happen. In my rebuttal on closing, I asked the jury to imagine what could happen in the room in that amount of time, and I asked them to all close their eyes while I timed out 2 minutes and 17 seconds on my watch. After about 60 seconds, 2 of the jurors started crying. I knew it was going to be guilty right then. Thank you for watching, and please subscribe to my channel for more Reddit stories. See you in the next video.